Big shout out, big shout out, big shout out, big shout out. Thank you for being here. Very appreciate it. It's Jrod on point. Is the host of the most Ting to the Tangle, the Yin to the Yangle. Favorite brother, your mother's favorite son, the black sheep. Very happy to be here in Jrod on point live. It's gonna be the live stream show. You know what I mean? Like here's where we just gonna kick back, spend time, have conversations, do open panels, and we're just gonna kick back, relax, and have conversations about the Idaho 4 and Bryan Kohberger case. Today's topic, we're gonna be talking about possible new trial date. That's why it's in question mark. Possible new trial date. We see that possibility coming. It seems that is no new evidence after the discovery deadline, and if it's any new type of forest as what they could utilize as evidence is really none of the above. So big shout out to the 21 people watching. Thank you for being here. I appreciate it. Get on the chat room, talk to me nice. Make sure you subscribe to True Crime chat rooms. Make sure that y'all go and subscribe, search True Crime chat room. Go to my homepage here on this channel, and you're gonna see the D-Word Entertainment Network channels. So make sure that you subscribe to each one of those channels, and also subscribe to our partner, Holly Martin. Very appreciated. Big shout out, big shout out. Make sure y'all go and subscribe to Miss Holly Martin. Show some love. Channel is growing. Content is doing great. And it's very, very appreciated to be part of the team. Big shout out to me, Holly Martin. Make sure you show her some love, send some coffee. Hit the tip drawer to the Cash App, Holy Mart. You know what to do. Big shout outs to you. Thank you for being here. And if you see any value in the content we provide here in this channel, Jrod on Point Live, make sure that you know what I'm saying, keep it humble. Buy me a house, buy me a car, take the family to a trip. Big shout outs to y'all. As always, we keep it humble. We work for nothing but truth and transparency in the true crime community. We'll make sure that we just keep it couple static, no pun intended. Big shout out to Lana. Big shout out to Harsh Reality, Sluty Goose, Speak Van Holding, and all the other partners. Big shout outs to you. Thank you. It very, very appreciated. Make sure y'all subscribe, and please make sure like, subscribe, and share the content. Make sure that you tell all your friends and family members that we're having great conversations here. We just keep it right down the middle. No diddy. We keep it a couple steady. Big shout outs to you. So we're gonna start the topic, new trial date. It seemed that in the conversation and the latest status hearing in Ada County, first hearing was very interested the pace that the new judge Stephen the work in the pace and the control of the communications. You know, we understand that it's a gag order. We're gonna talk about that too pretty soon in a couple of next minutes. But I believe that due to the it's a standing gag order as we speak. The pace and the tone of the conversation was very direct. All the calories, all the grease was cut off. The meat ain't was literally meats and potatoes down the middle, just how we like it. No diddy. We appreciate everyone watching. Make sure that you like and subscribe and enter the conversation in the chat. Just talk to me nice. Be nice. Chat, 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 chat. So we're gonna be taking a look at. We're gonna take a look at real quick we probably would just, you know, go and browse and probably watch the whole thing. Let's take a look at the latest status hearing. The sounding was a little bit not too great, but it was great as access, and it's good that we could still access the footage from the main source in Ada County. Big shout outs to them. Big shout out to Judge Hippler, Stephen Hippler. It's gonna be, I think it's gonna be a good thing having a new judge, just taking a look at the whole transcript, you know, and having a new perspective. You know, it seems that this judge did his homework in the case. He's seen the transcript. It feels like he was fully aware of the motion, early motions, and decisions that's been taken by the judge, the resolutions of those motions, and I mean the whole conversation, emails and everything. Like he had access to everything. I think that's why the poise, the word, the language control was very precise, in my opinion. Let me know, comment on the chat how you feel about it. Let me know how you feel about the new judge and the new setting. We're gonna be listening to the new status quo. See if we could pick anything different. I already watched it quite a few times. We have a new video coming out about this hearing. I did enhance the sound and, you know, do a little plug in it. You know what I mean? No Diddy, you know, plugging D Word Entertainment, and of course myself. It's pretty good. I think it's gonna be great content, especially for the people that like to do research. That's the main reason why we upload. Make sure that y'all subscribe to Jrod Point, the main channel. But I think that's why I upload the hearings, because for those looters and for those viewers and just random individuals that just come across the content of the Idaho 4, in my opinion, it's very good that when we upload those videos, like in the edit version, like cut up the degrees, just make it organic, and so we could just watch the hearing without, you know, the pause and without the breaks and stuff like that. I think that's the biggest reason, and actually including it for myself also, like, so I don't have to go to no one else's channel to watch content that I watch myself, that I study myself, you know. So I watch a lot of those hearings just to keep myself aware of what is being said in court. Let me know in the chat if you are one of those like myself that like to pay attention and actually, you know, take our time to listen to the content in court, so we could have like a clearer idea instead of like listening to no one else. You know, I like to do my homework myself. So without further ado, big shout out to everyone watching. Let's listen to Stephen Hippler, Bill Thompson and team, and Ann Taylor. I don't want to give you no type of how can I say it? I don't want to spoil it, but if y'all pay attention to Ann Taylor's body language, again, I'm not trying to spoil it, but if y'all pay attention to Ann Taylor's body language, she didn't even look at the prosecution team's table, not once. And literally in the way she was sitting, if you could tell, like in the whole courtroom setting, she was literally kind of like sitting there giving her back to Bill Thompson and team, literally, like not like fully, but it's like she's giving like the shoulder to them and really not even acknowledging them. Not I mean, she was being polite about the topics, but you could tell that it was tension in the air. That you could it was that the tension in the air was so tense. It was so, no spoilers again, but it was so intense that you could tell Ann Taylor was not happy. Like, I believe that in the discovery that he was just given to whatever was left, if any, because it sounds to me that whatever they give to Ann Taylor, it was more of the same things that they already got before. We a little bit extra, like almost nothing over the top to make it look like, well, we give you some new stuff, but then it was like a good 80 to 90% the same stuff they already got, and then just whatever extra they didn't want to give just cause whatever reason. Because that's how it sound to me. Correct me if I'm wrong. Hit me in the chat. Talk to me nice. Let's listen. Big shout out to everyone watching.
All rise. District Court is now in session. Honorable Judge Hippler presiding.
Be seated. All right. Good afternoon. This is State v. Kohberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Lake County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
All right. Thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Bryan Kohberger, Elisa Massa, and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have.
I really want to highlight what the judge just said there, because actually kind of like it did hit me a little bit late when I heard it. But then I was like, whoa, 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 whoa. At least we starting with listening, the first things that come out of the judge is obviously like he's heartfelt all about how he feel about, he's really not pleased with him being there taking care of this case. Again, this goes back with my assessment about the judge not being happy or pleased with in the way Layton County has taken care of this Idaho full Bryan Kohberger case. In my expert true crime opinion, I believe that due to the homework that Judge Stephen Hippler has done within the merits of this case, the ethics that is being used, the standard, the consistency in this particular case, things that, again, like Ann Taylor was repeating to the judge, consistency is very important. Case log is very important. Due process is very important. The rights of the defendant at the moment in court, it seems that some violations, it seems that it merits to a malicious prosecution to a certain extent. And I believe Judge Hippler understand the language, which in the way this case is being handled by the authorities in place. In this case, Judge. Again, he could see the emails and everything. First thing he said that he's really not pleased nor happy of being there handling this one particular case, because again, this guy handled multiple overseas multiple judges at Ada County Courthouse. So first and foremost, this guy knows how to handle a court case accordingly. I mean, again, we're gonna give Judge Hippler, the fully extent of the benefit of the doubt, because we not in no type of shape or form has no type of bad record on his own court decision in transcript. So like his court decision in transcript as a judge, it looks like, to me, it looks very good, very fair. It seems as a judge is very fair, very polite, but very down the middle, very serious about things. So that's good. They're very, very smart, very eloquent, good tone and pace manager. We see what's going on here. But in some way, it tells a lot the demeanor that the judge, I mean, is bringing to the table. Like, well, it seems there is a lot of BS going on in this case. We just gonna make sure that not just the prosecution, but the defense team and everyone in the courthouse act accordingly, proper, show professionalism, and give a good showing to the community, that so that they could feel secure that in the way this case is being handled swiftly. I can appreciate the tone. Big shout outs to Judge Hippler. But again, no spoilers. Just look at the body language of Ann Taylor. I believe that the Ann Taylor, if you ask me, she gonna hit with a smackdown of motions to get this case out the way and done. That's just in my opinion. Because these sound very, very like bottom line. If it's gonna be a trial, let's make sure that, due to the new developments with the unfortunate death of one of the team members in the defense team, rest in peace. I think, if I'm not mistaken, the expert had to do with the let me see, mitigation process, if I'm not mistaken. Anyone could correct me if I'm wrong in the chat room. Big shout outs to y'all. Thank you for being here. Very so much appreciated. My name is Jrod. So let's continue and listen to Judge Hippler laying down the rules how it's going to be in Ada County. It's like saying, you know, all that play that y'all have going on in Layton County, the bus stop here. It's a new sheriff in town, so let's go. I like the tone.
Have appeared in front of me before. When you file memorandums of law, briefs, etc., please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only. That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be.
I want whoever is gonna watch this on replay, or anyone that is here watching right now at this moment, comment in the chat room. Do y'all believe that the Goncalves family already got to Ada County far as like making demands, like far as like, you know, pushing a nice and kind but direct letter to the judge, like, you know what I'm saying? We're not gonna ask you too much, but we do request the consistency. It stays partial within, you know, having the defendant coming to court, doing his presence in court in the proper jailhouse uniform as an inmate while in pretrial, while in, you know, all these hearings that will come before trial, if trial is due to occur. Do y'all believe that the Goncalves family sent a letter to Judge Stevens Hippler? Comment down below. Comment in the chat. Is Jrod on point? We got questions. Because the judge, you know, I believe that he been courteous, you know, gentleman, you know, allowing at least for these one time at the moment, first time welcome bases to Ada County. It's like the judge letting them know, welcome to my house. Yeah. So in the same way, he's made it clear that consistency is very important too in all matters within the law, according to the law. And that's great. So it seems like, well, I do not disagree. Jrod on point, in my opinion. I do not disagree with consistency. Because again, we you know, we like around here, we like due process, we like consistency. And in due process, in my opinion, it's okay for the judge to decide Bryan Kohberger will come to the courthouse in the proper jailhouse inmate uniform, which again, I'm not against that for the pre-trial. It seems that it's consistent with earlier procedures within the courthouse. So I don't agree with that. Like, I mean, I don't disagree with that. I'm totally okay with it. But what y'all think? Did the Goncalves family, again, big shout out to the Goncalves family. Did the Goncalves family send a letter to the judge? I wonder. That'll be good to know. I mean, there's nothing wrong with that, if you ask me. I think that they have the right to make the presence felt within the head of the courthouse. I think that's okay. You know what I mean? I don't see no wrongdoing in that. Unless the letter it was, asking for favors or whatnot, outside of the law, which I don't believe at all whatsoever. In the way everything is being presented. Um, let's continue and listen here. And then, again, I don't disagree with consistency.
My intention will be that Mr. Kohberger will not be present for that hearing because part of what we will be discussing are security measures. And I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about, so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case.
Whoa, 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 whoa. Okay, you see, it's in my mind. It's really like very it's in my mind far as the threats that were alleged in the poll. I don't want to believe that no one, like, again, in that, because again we keep mentioning the Goncalves family. Big shout outs to them because it's like they are the most active, and they actually had expressed their feelings about things, especially about the what Kohberger should be wearing in court. Again, they mentioned it in that interview. And they also, not them, but it was people again in Layton County. They said that, far as the allegations that in the survey that, a lot of people was about it, try to do the good old boy back in the day with the justice type of like, um threaten to violence to in the against the courthouse and whatnot. If you ask me, in my opinion, I believe that some kind of threat, because again, to have, okay, let's say the judge could have just said, just to keep consistency with what we do here, he could have said that, just again, not highlighting the matter of security. Like, if you have a security matter far as like, well, if Kohberger keep dressing as a civilian for the pre-hearings, we already had a threat that if Kohberger comes in civilian clothes for the pre-hearings, some type of violence would occur within Ada County or towards the house of Ada County. Like, we have not heard nothing like that, but to me it sounds like when he mentioned Kohberger's clothing, and in the same sentence he mentioned security within the transportation back and forward from the courthouse to the jailhouse. Again, the clothing is mentioning. At the same time, it's mentioning the transportation and security of not just the inmate, but the officers also, the CEOs from the sheriffs. So, in my opinion, I believe there's some kind of threat far as the, again, take this with a grain of salt. It's just my opinion. There's some kind of threat as far as the dress code, the pretrial hearing dress code, and someone made it clear somehow to authorities that if that's a real problem, that there's some, a group of people would have not riot but protest outside of the courthouse or whatnot. I believe that something like that is happening, is possible uh behind closed doors. But again, it is very particular. The Judge Hippler is mentioning Kohberger's clothing in the same sentence that, talking about transportation, and got to talk to the bailiffs and the sheriff's staff of transportation. Again, he's very particular that he put in those two uh topics within the same sentence together. Let's listen.
I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that.
Again, I like in the way it's being presented. This presentation, this opening, it sounds very polite but very correct, very, very serious, very, very down to the standards of the court. And I like the conversation. And again, it goes back to my statement that I 100% believe that this judge, due to that he oversee a lot of judges, and he actually is the one that make the standard for other judges in that courthouse and whatnot. I believe that he understands the gravity and how serious this case is. It's nothing but granted, and it's a most to actually do his own homework in the whole case. I like the language, I like the tone of Judge Stephen Hippler. I think that it's a great presentation of a judge. He's very good. Not impressed, because actually I expect for a judge to be that way. And it's good, and it's good. It's very healing to see that after the judge performance in this case, it's good to see someone, that it actually pays attention. Because again, with these words that he just said before these pause, it lets me know that he has read the transcript. He actually watched the footage of Ann Taylor and Bill Thompson different presentations on different hearings, the tone, even Judge mentioned it, the attacks and stuff like that, the he said, she said stuff like that about the discovery and whatnot. I believe that this judge had, all the red flags within this case. He already know what is being in the past. So again, welcome to Ada County type of laying down the rules. This is my courthouse. This is the standards. If by any chance, again, we don't want to say that the prosecution is in shambles. We don't want to promote that, but just for what we have seen from the prosecution team and Bill Thompson, again, we're talking about Bill Thompson, well expert within his own career. 30 plus years. He's about to retire. Hundreds, if not thousands of cases. He seems not prepared. And if you ask me, that non preparation, like that bad performance, in my opinion, is due to the lack of evidence. It's like how the man, as a state attorney, a state prosecutor, is gonna act like a Goliath in court when he don't have, at this point, I believe they don't have nothing. Because again, in a way, we seen Ann Taylor not impressed with whatever was left. It just tells me that it was really nothing there. Like, it was just more of the same. The whatever 17 motions to compel or whatnot, I don't know if he got to 20. But it was a very high count of motions to compel evidence. And by the time everything got discovered, I believe she was actually not impressed. I believe that it was exactly what she prognosticated. That it was a little bit of mumbo jumbo, we a little bit of nothing, we a little bit of fabricate this. Let's just say this to get to that. After we get to that, we just put 2 and 2 together, and then those 2 and 2 that we put together for the grand jury, we're just gonna throw away the chicken scratch of how we got to that conclusion. So yeah, we give you the conclusion, but then we're gonna throw away, which actually they need to give to the defense team, the chicken scratch of how the cast information about the cell phone data, all that information on that hearing for the indictment, and then the officer from Moscow PD, the detective, after put the cast together, he erased how he got to those conclusions. So if you ask me, how can that indictment stand in court and through any procedure when what he got him locked up, what he got him arrested, was the IgG that is not going to be used in the court of law nor in trial. That's why you don't hear it mentioned no more. Ann Taylor got whatever she needed out of the IgG. That's out of discussion. Motions for that should come too. Then also, we're going to see here and see every little alleged evidence, because the IGG got him arrested and he's not going to be used. But then when Bryan Kohberger had the chance to get his freedom, he got hit with this secret grand indictment, which was crafted, like, again, the most solid evidence that they could have used to actually, like, put the nail in the coffin, was crafting that cast, that cell phone data cast, and the way they put it together was very convincing. But again, the homework and the way you got to that decision and those conclusions, you deleted it when you should have known. And if they don't know, they shouldn't know. I mean, again, if they knew better, they would have done better. But then now you come and delete evidence, because that's tampering with evidence. That literally, that cast that was created to have a indictment to come back at the third day is not valid, because how you got to those conclusions at the moment got deleted and destroyed. So then now to reconstruct with the same information they had available at the moment, but to reconstruct it now with all the information of how they created the cast for the secret grand indictment is gone. It was probably never there, but he knew how to put it together in the way to make it look like, and that's all they needed to make sure that Bryan Kohberger don't get out a secret grand indictment. And boom, just like magic, Kohberger's been locked up all the way up to this day today, a year and plus. No shame on his game, because he's that man's been there, and he goes to court. He don't flinch. Kudos to him. Like, big shout out. Like, well, hopefully, if he's not guilty, he get out of this. But well, if some proof out of the left field come up and be like, well, but we have this footage, or we have this something that is reliable, something solid, something with substance, something organic, something copacetic, comes up like, yo, yeah, that was him. He cooked. If they had that, which I believe if they had that long time ago or what, now even if they had it now, they didn't have it before, I believe they would have even mentioned something about it or presented. I believe that if you ask me, if the prosecution had anything solid right now as we speak against Kohberger, the Ann Taylor know that she couldn't fight that, she would be pleading out. She would advise Kohberger to plead to something to save his life. They're not talking about none of that. They talking about, let's put these motions in, let's get out of here fast. That's what it sounds to me. Comment down below in the comment section or comment on the chat. Be nice to me. Let's keep listening to Judge Stephen Hippler. Big shout out to Eddie County. Let's go.
I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court.
Again, this is another thing. These words right here is another thing that makes me think like he's fully aware of the transcript. Because to the 100%, he could have seen Bill Thompson to trying to win a case with no substance. This is what he tells me in the way Stephen Hippler, the Honorable Judge Stephen Hippler, make clear in this presentation that it's not about getting a win. Even though you don't have evidence, it's like if you have evidence, do all the hooply blah blah that you want to do because you have substantial evidence to do and say and act however you want to act in court because your evidence is powerful. But if you, as the state represented, you are a representative of the state and the victims, you don't you knew you didn't have a case. Let's say let's give it let's give it the benefit of the doubt. Let's say that in a way Moscow PD detectives presented the case to the prosecution. It was good enough to have the prosecution pushing this paperwork with this type of narrative. Because I don't want to spitball and be like, well, they purposely team up knowing that everything that Moscow PD presented to there was nothing but garbage. But it was enough for them to stick the spaghetti on the wall to Bryan Kohberger and have him kidnapped, like legally kidnapped. Because believe me, it's ways that the law could be used illegally in a legal way. For those that know about the law procedures and stuff, is ways that court staff and this is the corrupt people that we're talking about. We're not talking about everyone. We're talking about the corrupt people. Corrupt court staff, corrupt sheriff, local PD, possible state troopers and whatnot, highway troopers and whatnot, local mayor and mayor staff and whatnot. We have very corrupt University of Idaho, Scott Green and staff and whatnot. And now we having all these corrupt individuals due to that they are all connected and pushing the same way. They're all pushing together to one purpose and one cause. It's a chance here. It's a possibility here. It's not far-fetched to think that a whole Layton County could have plotted together, all players involved, except Ann Taylor. We're going to give Ann Taylor the benefit of the doubt for now because we don't see nothing shady about Ann Taylor at all. In the beginning, we was like very tough on Ann Taylor, but after seeing everything that we have seen, we're going to give Ann Taylor the benefit of the doubt in the way she's being handled herself in court. We are going to give Ann Taylor her benefit of the doubt, which is granted. She won that respect. She gained that respect. So big shout out to Ann Taylor. Let's continue.
All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That's
Gag order. Gag order. Alert, alert, gag order. I said it on my latest live stream. In one of my latest live streams that now I think it's in members only on the Jrod channel. Become a member on the Jrod channel so you can see all the good stuff and have total access to the vault. I believe it's good that he mentioned the gag order because I knew and I said it like I believe the gag order topic is gonna be mentioned. I believe there is nothing right now that indicates that that matter of the gag order has to be taken care of. I don't think like Ann Taylor already made her statement representing Bryan Kohberger, saying that the only reason why they went for the gag order, it was supporting the intentions of the state. So they threw Bill Thompson under the bus. But again, I give you my own take that I really thought, if you ask me, if you really ask me, I believe that Judge he was prosecuting this case with Bill Thompson. And I believe that it could be is a chance there. They could be Judge that actually came with the idea for Bill Thompson due to all the merits in the case. It's like, listen, no one needs to know what's going on here. We need to put these. This case is not looking good, and there's gonna be a lot of people talking about this. So let's just leave it alone for now. Let's see if this case died down to see if by the time the truth come out, not a lot of people will care as much as the people that he cares right now at the time being. It's all like mental, psychological warfare to the 100%. But big shout out, big shout out. Let's go.
still remains in place. And unless I, for some reason, remove that order, it will stay in place. And I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims. And I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that.
And again, at this moment, I see the prosecution staying quiet and Taylor staying quiet. The gag order was mentioned and both parties stayed quiet. So that I believe, in my opinion, that Ann Taylor's gonna stick with the gag order, is gonna write it out unless something shady come up that she really need to have like the public opinion. You know, like in the cases at some point, sometimes that if the information is so in favor and exculpatory towards a client and towards a defendant and it's a gag order, I believe that a good lawyer is consistent with wanting to have a gag order be taken away because they want this exculpatory evidence to come out to the public opinion, especially if the defendant, which in this case Bryan Kohberger, is being his character, his persona, his image and appearance is being slaughtered and assassinated out there, almost in the same way, unfortunately, the victims. You know, like it's not far-fetched to see multiple victims, not just the unfortunate young victims in the Idaho fall to be victims, but also it's a possibility and a chance that Bryan Kohberger is more of a victim than the roommates, which we always have to tell our audience that we do not believe that Bethany Funky and Dylan Morrison, we don't believe that they are victims. We don't believe that they should be called and considered victims due to the dating. It was no harm upon them. It was no nothing. It was no broken nail, which again we don't wish that upon nobody. They you know, I guess their luck, it was amazing, or their or either their luck was amazing or they knew the killers themselves. It's one of those. Okay, because for you to survive, like everyone around you dead and you survive, is either you knew the killers or you are one of the killers, or you are both the killers and people to help. You know what I'm saying? It's grounds to believe these type of things, because at this point, with everything that has been presented in court, alter suspect, which in the beginning of this case, we had other suspects that we have plainly talked about here. Way before Bryan Kohberger even came to the conversation, we have other suspects. We have other alter suspects. I share my thoughts and my homework and my data with Moscow PD at a certain point. So it's like the information that I provided, it was like the most common sense. It was like the really, really in detail. I don't know if it was the timing of it, because again, I waited for them to actually tell the public that the obvious suspects, were clear, which at the moment that this happened, it was like what, 2 weeks around the same time I called a little later, like a day after they told everyone that the obvious suspects, the inner circle, family members and all, got cleared. How? When it's obvious that not one bit of investigation against no one of the University of Idaho nor family members did occur. It was all a sham. It was oh yeah, we investigated. How you investigated when the majority of the warrants that y'all requested was after Bryan Kohberger got arrested? What are you talking about? What kind of homework you put in this case? What kind of work Moscow PD did in the first 48 hours? Nothing. I believe at this day today, there is not one bit evidence that it could tell anyone that Moscow PD actually investigated this case. And you know how we know this? Because the extra altered DNA that it was at the house located around the victims that they ignore. If you ignore those DNAs, but then you went so hard on this other DNA that was found close by that other DNA that you ignored, but it was a reason why you and Moscow PD detective ignore that DNA, but it was after you had the comeback of who that DNA belongs to. I believe that it was some DNA swaps to a certain people. I believe that it was some DNA swap to certain people. And when they found out that that DNA hit the mark to the killers, and the killers are students of the University of Idaho or related with big members of the DA office or whatnot, they are doctors or they are even staff of the University of Idaho. They are like the beloveds of the 1% of the Greek life community. They are the future of the Greek life community or whatnot. This is one particular group of people. For you to be the killers of the Idaho Full, and at this day today, you're still out there giving a bad message to those students in the University of Idaho. They actually know exactly what happened that night and who were the killers. The community is literally terrorizing. Listen, the Greek life community at the University of Idaho is a terrorizing Moscow, Idaho township or cityship, and is terrorizing the students of the University of Idaho with the possibility of having the killers still out there, and they all know who's the killer. The community know who could they be protecting. They were talking about the community being thinking that, well, if we grab someone, even if Kohberger is innocent, but as long as we grab someone, at least we could have the outrage of the community to come down, because we have a lot of people in the community. Because don't forget, in the very beginning of this case, it was made very clear that the killers were students of the University of Idaho. And as soon as the authorities and the University of Idaho staff and Scott Green and everyone with the whole state of Idaho authorities heard what the community was talking about, because they knew what happened. Everyone know what happened. Do you remember when Ann Taylor said that over here we could have like 400 witnesses? Who you talking to? For Ann Taylor to say that she have a list of 400 witnesses to talk to, that means everybody, every student, staff member, Scott Green, everyone knew what happened inside of the house and who did it. That's why the outrage was going so crazy that even Olivia Goncalves had to send a message through the news media outlets to stop inventing stories, to wait for the facts and stuff. And this was a week after the murders. The Olivia Goncalves is in the news media outlet sending messages saying that stop the gossiping, because everyone was talking about everyone was talking. But it's so sick to see the Moscow PD acted for the cameras like, we need your help to resolve this case. They tell the community, we need your help to resolve this case. The community flood the lines, telling them who was the killers and the reasons why, and yada yada yada. And here we have Moscow PD, FBI, and everyone and their mother, not literally, but everyone in law enforcement, everyone in the DOJ, everyone in the University of Idaho. Now they have to do damage control, chaos control, and Scott Green told you exactly how he did it in his book. It hit different. When we could see the corruption within the investigation of the Idaho 4, and it's very right there in front of your face. You just have to be a grown adult that have lived a life, that know what's out there besides whatever you know about your own life. You just have to be a human that research and know what's going on. Again, if people comes to the Idaho 4 case, but don't do their homework on not just Moscow, Idaho. You have to do your homework on Layton County and the justice system in that area. And then now you have to do homeworks about the University of Idaho, on all the murders related to the University of Idaho, that been drained, flushed down the toilet, water under the bridge. Nothing happened here. This is why sometimes I really, really, focus on highlight to the people. Create your own conclusion due to the homework that you have done for yourself. Don't let someone tell you what to think. Just sit back, relax, and just do your little homework when you really are interested in the topic or in the case. Pay attention. Just listen. Stop the talking, do the listening. And you might end up finding out exactly what's the problem or something, and you might be the next one to be the problem solver and breaking down these cases in the way we do here. You probably one day be like, you know what? I see what Jrod see in these cases. It's just very self-explanatory. It's all about the common sense of everything in life. Big shout out to everyone watching this Jrod. Make sure that y'all click like, subscribe. Let's listen to Ada County and Judge Stephen Hippler, Honorable Judge Steve Hippler. Let's go.
Let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
So long story short, Bill Thompson just told the judge, like, well, Judge, we here. But I really don't have nothing to share. I don't have, I don't even know what I'm doing here. Like, he went there, but he didn't have not a matter to bring to the table when asked by Judge Stephen Hippler. If the prosecution had any discrepancy or anything, this was their opportunity to let the presence felt. So again, no discrepancy from the prosecution. They don't have nothing to talk about. The only thing that they could, have anything to talk about, it was if the discrepancy about the trial date come to occur and they have to talk about it, then now they would like to enter that conversation and whatnot. But they also don't have the details of the reasons behind of how far the defense team were on the process, that they have a deadline or whatnot. It's very good to see that the prosecution don't have nothing to say. Let's continue.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court.
You see, this is what I'm talking about. And Taylor not playing around. They listen, Bill Thompson don't have a problem. Big shout out to everyone that voted. We got 20 votes. Do you see a new trial day for the Idaho 4 Bryan Kohberger case, like what they mentioned in court, May 2025, 2025? Please vote. So far, we have 95% and yes, they see an extension to the trial date, and only 5% voted no. Big shout out to ya. We're gonna finish the poll in quite a few more minutes. Make sure that you vote in the poll. Make sure you click like, subscribe, and share the content. But yeah, this is what I like about Ann Taylor. You see, prosecution stand up very nice and polite. We don't have a problem, you know, everything good from our side of the fence. Like everything is Gucci for Bill Thompson, right? But then now Ann Taylor stand up is like, oh, okay. So now that this is my chance to talk about problems and issues. Oh, here we go. Big shout out to Ann Taylor.
Court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet.
So they have a very good amount. They have a very good amount of whatever was left in the prosecution side of things. But again, her body language and the concerns about what she just got, and again, Ann Taylor, due to the gag order, she's not sharing like the details within the discovery. But the prosecution would tell you, like the lady of the prosecution, she didn't even want to talk. She didn't even want to say nothing. But even the prosecution tells you that whatever they give to the defense team, it was more kind of like more of whatever they had, but a little bit of new stuff that it could be considered new stuff. So, but it's still a lot of content to go through. It's a lot for the review. It's totally understandable. Is a good reason, you know. It's a lot of work to do. It's a lot of work to do that. Again, just because the work that I know the defense team being wanted to do, and again, this is why the whole reason why they had all those motions to compel, because they want to get to work. They want to get things done. Let's get the show on the road. That's my personal opinion on what I see that Ann Taylor's been delivering her presentation. It's just like, give me what you got, give me all what I need, and if whatever I need you don't have, well, motions will come. That's it. But then it seems that now we are in that process right now. So now they have whatever was left on the archives of the prosecution team far as evidence in the Bryan Kohberger case, and then now, you know, they got a lot to do far as that and the upcoming issues that she's gonna present. Big shout out.
So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to
Rest in peace and our condolence to the family members of the experts of the defense teams. Rest in peace.
refill that role, to have a new expert to do the work that that expert was hired to do. But we are not progressed to the point that I'd hope to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware.
Whoa, 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 whoa. So that means that Ann Taylor, as we speak for this court hearing, she's working pro bono. As we speak for this court hearing, in my understanding, due to that they don't have a contract of representation of Bryan Kohberger for Ada County yet, the funding is not available at the moment. That don't mean that Ann Taylor won out the case nor be out the case. I want everybody to be very, very aware, because you know you're gonna see content creators saying like, "You see, I told you that Ann Taylor would be off the case." Again, don't listen to those content creators, because again, I don't see nothing that would indicate me that Ann Taylor had the intention to not represent Bryan Kohberger, because it seems that right now on record, as we speak in this hearing, Ann Taylor nor her team are getting paid for what they doing in this footage. Big shout out to Ann Taylor and team. It seems that even though they're not getting paid, they're not on contract yet of representation, they there and they making it full, that they making the court fully aware that that's an issue that it needs to be taken care of. Let's go.
Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case.
So that means that if a contract is not put in place soon, is the chance that Ann Taylor wouldn't be available to represent Bryan Kohberger with her team. Nor to fund what they need far as for pushing paper and whatnot in investigation of for what they need. And that's a good reason to get off the case due to lack of funding. But I don't know, if you ask me, due to the Ann Taylor and her team know so much about this one particular case, I believe that they know in the back of their head that they could win this case. They could not even win it, is get it dismissed way before trial date. I believe that in their heart of hearts, they understand and know that is a chance and a possibility that they could dismiss this whole case due to lack of evidence. I have mentioned it here many times. I believe that even though if fundings and the manner of payment doesn't get met, I have a feeling that Ann Taylor and her team would do all the work pro bono in the same way they doing it today in this hearing. This was like yesterday. But in that hearing, in this hearing that we're presenting today, For in the way this sounds like, I could be wrong. Comment in the chat or comment in the comment section on the replay. Big shout out to you. Thank you for listening to Jrod on Point. It seems like Ann Taylor and team would work pro bono because they know they could get this case out the ballpark. Big shout out. Let's go.
As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system, 12.2, as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing, that would come through the state public defense budget, essentially.
Okay, yeah, I want to make sure that people is fully aware what's happening here for those that don't understand. Ann Taylor now is a state defense attorney paid by the state of Idaho. Okay, so it's not as like, you know, what we call, you know, private firms or what they used to do, that it was private firms getting paid by the state on a form of contract by a certain rule. Then now the Ann Taylor become a state defense attorney paying by the state. Then now they redo the contract. Now the state will have full control of the money assets and how the monies get used and whatnot. Don't be surprised if certain requests. I don't know. I believe that now, due to the state have full control of the money side of things, I believe that now the state will make sure that everyone, you know, gets paid accordingly or whatnot due to the guidelines, under the guidelines, and also whatever is required for Bryan Kohberger defense, it will have a higher scrutiny to let go money. I think that Ann Taylor will have to present the gravity of the intentions of the reasonings of why use that certain type amount of money for whatever is the reason at the moment. I feel that now the financing will come direct through the state. It's gonna be a little bit more scrutiny of like in how and why you need this money, the reasons why, and all that good stuff. It's gonna be more strict, if you ask me. I like in the way these whole court setting and in the way the poise and the presentation of the whole thing. Big shout out to everyone watching. This Jrod on Point. Let's go.
I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about.
So the judge want to move it to May. He's seeing what's going on, and the judge recommend move it to May. Let's go.
The timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point, to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing,
Is that just your evidence, or does that include defense evidence?
well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
So 10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably take no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial,
That's
for our
for
evidence.
your evidence.
Yes.
Okay. So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer, I think we will find it to be difficult on jurors in particular. Jurors who may have children who are out of school, in terms of being able to spend time, go on vacations with them, et cetera. That's one.
So it seems like, correct me if I'm wrong, comment down below or comment on the chat. It seems like instead of June, the judge want to do May. So it's like want to do it sooner than later. Comment down below. Let me know in the chat for those on the replay. To me, it seems like that the judge wanna, if the trial that was for June, now he wanna do in May. He wanna do it before the trial date that he was presented by Layton County. Yeah, it seems like. Comment down below.
Concern. Second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had 2 proposals. One was to start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence in early September. And I'd like your thoughts on those. I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other 2 choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
And Taylor wants September. September 2025. Bill Thompson is okay, which again he did mention it. He did mention it to Judge. He did. But Ann Taylor, okay, so Bill Thompson is okay with May. But you see, this is how this whole setup about holding evidence up to the deadline. This is the consequences of that. Now that they got what they got, for them to be ready, it's gonna take a little bit longer than the summer 2025. Ada County Judge Honorable Stephen Hippler wants to move the trial date to an earlier time, May 2025, which I believe that the family members, like far as the Goncalves and the media narrative, should be very pleased and even talking about this. I have not heard news media outlets and no content creator talking about Judge Hippler wanting to move the trial for earlier, a whole month earlier, sooner than later. Which, if you ask me, is good. But at the same time, we want the defense team to be to the 100% ready to defend their client, for everything to be as just. So yeah, I believe that, well, if you ask me, it shouldn't be a problem to move it to September, as long as the defense team, because again, I believe that the defense team, when they mention September, it's like, well, if we force it September, we could be ready. But I believe to be ready, I don't know, October, then beginning of December, Christmas time, driving in the snow and whatnot. So I believe that if worst comes the worst, I believe that if this case doesn't get dismissed way before all this hooply hot, they might go with a May 2026. Because then they're going to see the problems. Well, if Aunt Taylor's going to be ready, it's convenient for her and ready for September, when actually school's open. Might as well, let's just leave it all alone. Let's just do May 2026. And hopefully that everyone is happy with that decision. And I think it will give Aunt Taylor more opportunity to get whatever information she will be able to get. And hopefully, if it's no serious evidence from the prosecution team, that it will make Bryan Kohberger guilty or whatnot in court with solid evidence. If none of that occurs, I believe that it might get dismissed pretty sooner than later. Let's continue.
So I'm not going to worry about the public defense change, because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away.
I believe that many evidence is being used in the wrong way. Like if you ask me, that's narrative sounding like. Again, that sounds like, the same way the legacy media and the news media outlets be saying, oh my God, so much evidence. No, it's a pile, it's a amount, it's a volume of whatever was gathered by authorities related to this case. That don't mean that everything that is there has anything to do with Bryan Kohberger. That don't mean that. This is why I believe that word is being used in the wrong way when they say, well, we understand there is a lot of evidence, because that make it sounds like yo, we believe there is a lot of evidence against Bryan Kohberger. No, it's a lot of data to go through. It's a lot of discovery to go through, but that don't mean that in that discovery is any type of guilt or exculpatory yet. We will find out soon. Let's continue.
So the one that concerns me that you brought up is your expert. I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert, if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet.
So they already have the replacement. That's good news. Big shout out to Ann Taylor and team. That's very good news. They at this time and point in this status hearing, they already had the remedy for the situation of one of the experts that has to do with the mitigation side of things, on the guilt side of things, if that ever occurred. It's good to know that Ann Taylor already have the replacement for that particular expert. That's good. That's great. Good teamwork. Let's go.
I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present. And maybe I would have been stopped from that with that deadline.
And if you ask me, it's fair for her to be honest with the court and let the court know that she seems, due to that now we have a new expert, that now this new expert has to study everything that this past expert have put together. Then now, after he soak himself within this information, now he or she have to keep the work going. But for them to get the work going, they have to be fully aware of the task in hand. That takes time. That takes time. It's fair for her to be honest with the court and be like, Judge, I will not be able to meet the deadline. You know, they could try or whatnot. Not very confident, but it's good for her to be honest with the new judge. Let's go.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you know, didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
At least Bill Thompson has a better tone in the way he been handling this case over there in Layton County. Now here in Ada County, we have a different type of Bill Thompson. Is very condescending, you know. He's like, you know, everything playing, get along, you know. That's good. It is good that Bill Thompson don't have nothing to instigate that situation. It was good for him to leave it as is, and let the judge handle that with the defense team, and then they'll have any further take on that after more information comes across. So that's great from Bill Thompson and the prosecution team. I think that was an olive branch. It was a very well deserved olive branch. That was good. That shows good sportsmanship.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
In a quick observation, it's good to see the judge is laying everything, like what's the issues, what's going on, what can we do to get the show on the road. Let's go. This is good.
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert,
Can you tell me if the one expert is a mitigation or a trial expert?
a mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
Your the time passes very rapidly, and I appreciate the court not asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
I believe that Ann Taylor misspoke when she said witness. I did pay attention to it. I believe she meant expert. She didn't meant to say witness at the moment. They were not talking about no witness. They were talking about the expert. So she just misspoke at that one time.
So understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we are looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that, I feel like I'm cutting my own throat in a sense, but that's realistic.
So here is a chance that even though the judge wanted for May before the trial time, before the trial day, a whole month before, it seems there is no way that that's even possible. I believe that at some point they're gonna decide to postpone the trial date, vacate that trial date, and extend it to either go along with the September that the defense team needs, or cut it even for everyone and do it May 2026. That's my take. Let's listen.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
It seems this Judge Stephen, Honorable Judge Stephen Wheeler, like Hippler, it seems that he's a go-getter, get it done, and you're gonna learn today type of. It's good things. It's good things. It's good things that he want to get things going. That's good. Ain't nothing wrong with that.
Could I have just a moment? Your Honor, we trust the court to do the ex parte hearing, see what's there and make the best decision and tell us what the expectations are.
I want you to pay attention. This whole time, Ann Taylor has not looked at the prosecution table not once, and she even had she's like shoulder them. Wow. I mean, if you ask me, I don't blame her.
Well, do you want to do that later today or you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right. Well, we'll give that a shot.
Again, and I repeat, it's very good that the judge is a go-getter, get it done. You're going to learn today. The judge is going to get it done in the same day. But again, that's not going to be filmed. They're going to have the ex parte. Bryan Kohberger will be on his way back to the cell, to the jailhouse, and they're going to have conversations, an update in a bigger, greater way, again, because it's a gag order. And I believe that in the ex parte, it's going to be just, straight up, this is what's going on. It'll be a more private setting, and more information is allowed to come out on that type of form, that type of setting. So yeah, it's great that the judge want to get her done. That's good.
All right. If if I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month, with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel.
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judges?
This is my favorite topic right here. My favorite topic, discovery. Hopefully we don't have to talk about the discovery no more after this.
Last order and other orders.
You have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the, would you say 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure.
You see, again, here at this moment, and Taylor didn't even have to tell nothing to the judge about the discrepancies in the discovery. And this is why her body language and the reasons why, because whatever they gave to her, some of that she already had, and whatever was considered new was irrelevant. This is how it sounds to me. Let me know how you feel in the comment down below. Make sure you click like, subscribe. It's Jrod on Point. Make sure you get to the chat.
there were portions of it that was new information. I've not calculated.
She said a portion of it. And then she's gonna say she had not calculated how much is that portion of it when Bill Thompson just got caught in the first lie in Ada County saying that this young lady had done an extent of she fully aware and she's the one who's gonna give you all the details. You see her, she was arguing with him like right there. She stopped cold, like, I'm not ready to talk about this. And there you go. She got caught, not being ready about it, not ready for it. And again, this is, I believe, the first shady moment, looking shaky in the state and the status hearing is the first time the Bill Thompson and the prosecution team looks unprepared, not ready for the task on hand. And it's a shame. It's a shame that the experts, this is people that is, do years in college and learning the craft. And it's a shame that while Bill Thompson just said it, I'm gonna let her tell you because she's the most capable to talk about this. And y'all all seeing her reactions. She sit there, she ain't even want to get up. I believe that what, I don't know, because I'm not, I didn't hear it. But if you ask me, the body language looked like she was telling him, like, I'm not ready. What you doing? Big shout outs to them. But yeah, it looked bad. It looked bad for the prosecution, and Bill Thompson got caught lying for the first time. Wow.
Calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
All of it, Judge.
All right. Well, I will talk when we're finished here with Ms. Taylor without the state present.
So comment down below, but that sounds to me that they just got this. Wow. Yeah, literally. I mean, but if they got it on the deadline, they still have like what, 2.5 weeks with it already, and they haven't looked at it. If you ask me, in a way, sounds like if the state did not met the mark of the deadline, and it sounds like Ann Taylor and her team just got it. If you see Ann Taylor's assistant, she looked at Ann Taylor like, you're not gonna tell the judge. I could see these things coming. I think that the prosecution did not meet the mark of the deadline, and whatever they give, like the defense team, it was like garbage time type of nothing. Wow. It sounds bad. This is why you see I was telling you about Ann Taylor body language. She ain't even looked not once to the prosecution team. Oh, it's no courtesy from her. I don't blame her though. I do not blame her. I believe that she knows this case is a sham. It's just like they literally legally holding my client kidnapped. They went to Pennsylvania. They kidnapped this guy on a legal way. They found a way to legally kidnap this innocent man, drag him to Idaho somehow, convince him to skip his extradition hearing and all that process in Pennsylvania. It's like they told him, like, the sooner you get to Idaho, the sooner we fix this problem pop up. Oh my God, they lied to him. It was like, soon as he got to Idaho, we got you. you're not gonna get out of jail. They're gonna make sure you're not gonna get out of jail, because soon he was a chance for him to get out of jail. We are bond hearing that it was time for him to have like the very last bond hearing. They're gonna see, like, judge, hey, uh my client is being locked up this long with no evidence. Prosecution's not ready. They have not presented me with nothing. So my client is locked up with nothing. If Bryan Kohberger would have got out, it would be an outrage from the community. We know this because at that time and moment, it was like, damn, oh my God, they're gonna talk to Bethany. They're gonna get this man out. Bethany's gonna get this man out. They knew that. The government knew that. The University of Idaho knew that. They knew that they knew that the community of Moscow, Idaho, they don't have nothing to do with the University of Idaho, was putting pressure, letting them know, like, yo, we hear what's going on, we know. And if we got to know what's going on, that just tell you right there how much people know what really happened inside of 1122 Queens Road, not 1122 King Road. That house address was 1122 Queens Road. The cops called it 1122 Queen Street. You hear one of the cops in the body cam talking about it. So it's good to see that all issues gonna get done and fixed early, but at the same time, my biggest concern is if Bryan Kohberger gets to get out and be a free man, due to that is really nothing that he will point at him as any guilt at all. So people should be fair if that ever happened. What the prosecution and Moscow PD, FBI, and everyone in the law enforcement side of things gonna do if Bryan Kohberger get a dismissal? We listen. They don't even have to prove and see and show nothing. They, as long as they could show an emotion, that a dismissal for lack of findings, it should be granted. And if that ever happened, and that actually happened and occurred, what the government gonna do? What they gonna tell the families? What they gonna tell the community? What they gonna tell the news media outlets? What they gonna tell the big content creators that be talking all these BS? Then now you see them little by little pedaling back. Is some of those content creators the guilty? They literally they just oblivious and just delusional, and they just see things that are not there. And again, much respect. I'm not trying to be disrespectful. Much respect for y'all, to all of y'all. Keep doing what you're doing. Be successful in whatever you do. But it seems that the information they providing to the people right now, to their own communities, really no good. And it's good. It's good that these people like us, like me and Harsh and Sluthy and Lana and Speak Van Holding, Holy Martin, many others, that actually could give the benefit of the doubt until further notice, until further evidence they could be shown and be like, you know what? I think this man is cooked. For the time being, we cannot support that. It's not consistent, and we try to stick with consistency. Let's go.
In a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Bill Thompson sounds like oh my God, he sounds so new. It's like, why won't you want to be on the ex parte? Why would you just want to make yourself look at like, hey judge, hey, if you don't need me, you know what I'm saying, can I be out? But that's what it sounded to me like. He really don't care. It's like I don't. It's like he don't even want to be there because he's like he knows he don't have a case. So it's like he want one of those students like it's like, hey, I know that this might sound stupid to you, teacher, but if you don't need me no more, can I go? And the teacher is like, listen, why you even asking me that like mid-class? Like, what's wrong? Like, shut up. Like, you know what I'm saying? Like, that's how Bill Thompson, all respect to him, sounded to me. Like it's like, dude, why won't you want to be on the ex parte? Why? Because you don't want to hear what the defense team gonna tell the judge right in front of you, and the judge gonna look at you and be like, hey, Billy, what you have to say to what she had to say? And Bill Thompson is like, well, judge, listen, I don't know. It's the same thing he was telling Joe Judge. Like, I don't know. Listen, listen, ask them. Like, I'm just the guy with the beard. Like, what are you talking about? Leave me alone. I don't even want to be here. Listen, I should be in Mexico with some margarita and shit. Like, I should be retired. Listen, my buddies from the University of Idaho, Scotty Green, told me, like, listen, you need to do this one for me, dog. This is the last one, bro. This is the last stand, bro. We need to win this one. The college is about to crumble. We're about to lose it all. We might all be locked up for life. And Bill Thompson is like, okay. Stupid. Oh, sorry. I'm did not meant to say that. It's just for comedy. But yeah, I don't know. It's not good. That it's not a good look when Bill Thompson like said that. They just had to tell him like, yeah. What about just because you say like some stupid shit, right? Hey, now that you mention it, why won't you just you raise your hand, right? You raise your hand to be like stupid. Might as well just stick up with you flying, you're driving. The judge already know. But he's again for the camera, it's like, okay, if for the cameras you want to do that, how about I just like sit here and just torture you and just be like, well, guess what? Now you're gonna stay. Big shout out. Listen, hit different. Big shout out to the new judge. I mean, not new judge, but the new judge in the Idaho 4 case, Bryan Kohberger. Honorable Stephen Hippler. Big shout outs to him. I think this is good. I think Ann Taylor and the defense team, even the prosecution team, they're gonna be well taken care of in Ada County. This is sound good right here. Big shout out to everyone that is watching. Hopefully y'all enjoying the showcase.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Kohberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes,
So this right here tells me and you the prosecution team did not met the deadline for the discovery. That one is coming because they're gonna strike the death penalty and whatnot. They probably just gonna start probably schedule Frank hearing and just try to just get it all um out the case because it's irrelevant. It is nothing there. This needs to get out the case and whatnot. This is good. This is good for all parties, I believe, if you ask me. Um, I think that the family, like the Goncalves, could be happy hearing that the judge want an earlier day for the trial, but also at the same time they're not gonna be happy because it's like they getting teased, like, well, we could please the family and actually other related to the case if we do May a whole month earlier. But at the same time, it's consequences to that, and he don't want to face consequences to that. So I think I believe that he playing it smart because he see that it's no reality. Like I believe that he just said that to put a pacifier to the family. Like, well, the judge at least is saying that he want to go for a month early. So it's like the judge, in the smart way, pulling his tail of the fire and be like, well, you're not gonna burn me because I know better. And he looked it good when he said that he wanted a whole month sooner, but at the same time, they highlighting the reality that it's impossible. It's impossible. So if it's not possible for May either so that means that deadline that they have for June 2025 is a impossible deadline for to start the trial. So Layton County and Judge decided upon that, and I believe I believe Ann Taylor knew that this was going somewhere else, and they just let judge like have a last stand and be like, well, I'm gonna look good to the family. I know this case is getting out of my county. We just been playing delaying, and that's what the judge and prosecution be doing, delaying everything and stopping the state stuff. And if you have me, in my personal opinion, that's what the judge and the judge and prosecution was doing in Layton County. We could see the inconsistencies and whatnot, and at the same time now, then and Taylor let the judge is like, okay, we're gonna agree with this trial date for June 2025 because we know for a fact that as soon as this case gets presented out of this county, it gets to Ada or somewhere else, but in this case it's Ada, and they're gonna see everything on the transcript. It was on record and whatnot, and they're gonna see like, well, even though I'm saying what I'm saying, and I'm talking about Judge Stephen Hippler, even though I would like to do this again, what they talking about doing in May. At the same time, it's a lot of things surrounding that if the defense team believe that a bottom line for them to like rush it, for them to be rush it enough for them to be ready by September 2025, in my opinion, prosecution would not have a problem if the judge present to the prosecution even the imagination of presenting the beginning of this trial for May 2026. It'll be a go. It will be 100% a go, and everyone will be happy. The family will irate. I totally understand they're going to Calvers and everyone is going to irate. They're going to have the little show and whatnot. But at the same time, and you hear it first here in Jrod Point. But at the same time, everyone, far as the prosecution, I believe, yeah, the judge wanted sooner than later. But at the same time, the judge, which we could see is a fair judge, we believe the prosecution will not have a problem with that, because through that whole time, either Bill Thompson retire or he stay in the case as long as, you know, as long as to get this very last retirement check money. You know what I mean? Squeeze the cow all the way to, you know, the end of the road, even though he might lose this case. He might lose the representation of this case, far as losing this case, due to the lack of evidence. But at the same time, it's very good to see that is light at the end of the tunnel. We've been talking about this case since the very beginning. A lot of people made fun of us. You know, a lot of people criticize a lot of things, but they could not criticize the message. Like, they criticize the messenger, they criticize things that really don't matter, but they could never criticize our takes, because they knew that our takes is the closest thing to reality. And I like to do my homework. And even though a lot of people did not like what we was presenting, with the possibility of Bryan Kohberger being innocent since the very beginning, since like I've been letting people know, like, listen, chill out, like, you know, what you hear is really not what it is, because again, due to my homework, because the alter suspects is real. People need to start understanding that it's alter suspects since day one, and the authorities turned their back on the reality to create a fake reality to humanity and whoever listened to this case. But they don't, what they know and don't care is because their own community know what happened, and they really don't care. They're sending a bad message. They like the bad message because it's like it will create power and will scare people within their own cult, within their own group. It's gonna scare people like, haha, you know, I have these crazy dumbasses killing people. They already did it. It was their first time, because again, it was their first time, but they already curated. They will do it again. And you see him driving around people like it ain't nothing, when it's students and people from staff and it's people and officers that know the truth, and that should be criminal of knowing the truth about a case and turn your eye and you focus away from it to protect the interest and the money of the University of Idaho. That should be criminal. That should be punished by the book of law and the Constitution. They should be punished by the book of law. Knowing who's the killers and all the possibilities and the other suspects in this case, that the whole community give you the tips about, and even you got all the tips, you still went the opposite way because you don't care.
Anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But okay.
On that point, Your Honor, As you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So
Okay, thank you.
the others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do.
And that show ethic. That right there shows ethic. Because again, if you ask me, Bill Thompson should have know this. He should have know this. Like, if you're gonna be arguing in court, like, bring your people. Don't try to do it through a Zoom, because it's no substance. It's no real take. Doing it by remote is really no good take on that. You need to come to the court and perform your expose. Let's go. Big shout out to Honorable Stephen Hippler. It seems that he's a good judge. Good stuff.
Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right.
Thank you, Your Honor.
Back in a few minutes once the courtroom is cleared.
All rise.
And that was it for the presentation of the latest status hearing in the Bryan Kohberger case. I'm very happy to bring this great presentation to ya. I'm very happy to be able to do so. Big shout out to everyone that was watching, even though you was not on the chat, but I appreciate you. You watching, you here, you with me, you're listening to the message, and that's why y'all see me so focused on the message. Because again, that's the most important thing. Hearing and listening to the message, which I appreciate everyone that he was here listening. Thank you so much, so much appreciate. And for those that are going to be listening to the replay, thank you so much. Appreciate y'all. Thank you for clicking like and subscribing. Make sure y'all subscribe to Jrod on Point Live and subscribe to Jrod on Point, the main channel. If you see and you found any value in the information and the way we're breaking it down for you, please make sure that you send me a coffee, buy me a house, buy me whatever, send whatever you could spare. Thank you so much. It's very appreciated. Send it to the Cash App, TheOnPointFamily. Please click like, subscribe, and all that good stuff. Share the content. Thank you for everyone that he was here. And this is gonna be it for today. We're gonna just leave it here. We're gonna share more content in the main channel. Make sure you subscribe to Jrod on Point main channel. It's good to come to these forums, to these platforms, these very small 378 subscribers today. Tomorrow we might have 400, 500, 600, 700, 800. All of y'all gonna be very appreciated. Big shout out to all the subscribers in the main channel of Jrod on Point. Hopefully they find their way here to this channel, and hopefully they subscribe here too. Thank you so much. Thank you for being here. Make sure that y'all come back to get some more information and enjoy more true crime and the Idaho for Bryan Kohberger and other future topics. It's your favorite brother, your mother's favorite son, the black sheep, Jrod on Point. Believe in yourself, because I believe in you. If I did it, you could do it too. I ain't nothing special. I believe that you're going to take the best decisions in your life for yourself and for everyone around you. As always, Jrod on Point. Love each other. Take care of yourself. Take care of you so you can be able to take care of others. Have a great day, guys. Thank you for being here. I'm going to leave y'all with my favorite song, your favorite song. You so sexy. Enjoy, guys.
What?